Welcome everybody. Thanks for being here. We are gonna discuss filtering for copyright enforcement and data protection. I'm Frederik Borgesius. I work at Radboud University in Nijmegen, and I have the honor of moderating this panel. I'm going to quickly introduce the panel members. We're going to not give you more PowerPoint slides because we expect that you see enough of those. After I introduce everybody gives a brief introduction, then the panel members can react to each other, and then we ask you whether you have any brief questions. Yeah, so that's how we're gonna do it. And first here we have Rosanna Ducato, a postdoctoral researcher in law at the Université Catholique de Louvain and the Université Saint-Louis in Brussels. And she is the PI, the main investigator on a project on internet platforms and consumer protection. And she's also a fellow of the Trento Law and Technology Group in Trento, obviously. No, I'll continue to introduce everybody. Then here we have Anna Mazgal, who has worked on various international and Polish NGOs, and now she is a policy advisor, EU policy advisor at Wikimedia Deutschland, but based here in Brussels. Then here next to me on the other side is João Quintais. You can pronounce your name better yourself. Ex-colleague of mine at the University of Amsterdam, at the IVIR Institute for Information Law. So now he lives in Amsterdam, studied in Portugal and Germany, and has a lot of experience as an attorney and legal researcher. He's a copyright specialist, and he wrote a critical paper on the new copyright directive that we are discussing today. And then the last speaker I introduce is not Karen Melchior. She could not make it, but this is Asta Helgadottir, the assistant to Karen Melchior, who is a member of parliament for the Renew Europe group. And Asta, who we do have here on stage, studied at the Oxford Internet Institute, where she wrote her thesis on filtering for copyright enforcement. So we have a very, apart from me, we have a very knowledgeable panel on this topic of copyright enforcement. So now the brief remarks of the panel members, and we start with João.
Thank you very much, Frederik. It's a pleasure to be here. So it falls upon me in 3 to 5 minutes to give you a brief overview of what this Article 17 is about. So I'll be simplistic about it, and then we can dive into the details if you want as the conversation flows. But this is like the most controversial provision of, I would say, the most controversial provision of the new copyright directive. And it's I think it's better understood as part of a general push within EU law to increase the responsibility of online platforms. And other examples of this push, you can see them in the terrorist content regulation, efforts on hate speech, and the upcoming Digital Services Act that we are going to discuss a little bit here. So what is this article about? The general idea, or how this is sold, is to close the so-called value gap. So basically this perceived mismatch between the value that some online platforms extract from creative content, think YouTube, Facebook, etc., and the revenue that's returned to the copyright holders. We can discuss whether that is true or not, but what does the article do? So first step, who does it apply to? So it applies to what the article calls online content sharing service providers. This is basically a subtype of hosting platforms that host and organize and promote large amounts of copyright protected works. Examples include, again, YouTube, Facebook, Vimeo, but any type of platform that fits the definition and it's not expressly excluded, as are, for example, platforms like Wikimedia and GitHub. Now, what does the article actually do? Well, what the article does is a change in liability rules. So it basically, for these platforms that used to be, for the most part, although there was some controversy in specific cases, there used to be under the shade of a safe harbor, of a liability immunity. They would only be responsible if they knew about content and then would take it down, usually through notice by the rights holders. Now the platform is directly or primarily liable, meaning the platform is considered to be making what in copyright technical terms we call a communication to the public. So that also changes the incentive schemes of how platforms moderate this type of content online, from a more reactive approach to a more, let's call it, proactive approach. And part of the problem lies therein. Now, the mechanism, it's important to understand, because the platform does not use the word filters or upload filters. What the provision says is the following. These platforms, because they are now directly liable, are communicating copyright content to the public, therefore they are directly liable, therefore they must license this content. Now, for the majority of platforms and outside the field of online music, that's virtually impossible. So what the regime says, well, if that turns out to be impossible and you prove that you try to obtain those licenses or you made best efforts for that, there's an ad hoc regime, and that's a sort of what Miquel Pegueres here calls an ad hoc safe harbor. So a new type of safe harbor that says, well, in order for you not to be liable, you have to take certain types of preventive measures, and this is where the filtering comes into place, to prevent that content which the rights holders informed you that they own is not available on your platform. If the content is available and rights holders identify it, you have to take it down, but you also have to avoid that it's uploaded again. So this is where we talk about upload filters and re-upload filters. Now, maybe it's just 20 seconds how filtering technology works, because part of the issue is here. Most of the filter systems that exist out there can be categorized in two types, right? Facebook and YouTube build them in-house, and other companies like Audible Magic provide it off the shelf for platforms. Now, what Facebook and YouTube do with their Content ID and Facebook with Rights Manager is basically have a sort of fingerprinting or matching technology. You, as a rights holder, upload a file, they create a reference file or a fingerprint that's matched against what's uploaded by users, and depending on how the rights holder uses the tool, that can be either, usually it's not made available until the rights holder makes a decision on it, and it could be monetized or not. Part of the problem is that the new system basically incentivizes platforms to institutionalize such a system, and what we know about these systems is that they're basically quite good at matching one-to-one files, but they're terrible or incapable of recognizing context. Problem being that for copyright, context matters, as to for many things in life and many types of content. So for example, there are user rights, or if you consider them just exceptions, for parody, quotation, pastiche, that require an assessing, a legal assessment of whether or not that the context of that particular upload, although it matches part of the pre-existing content, falls under the exception. Filters cannot do this. That means that by default, the content would not be available online, and the technology wouldn't allow you to make that assessment. So this is part of the freedom of expression implications, and as Rosanna especially will discuss, also brings with it some data protection issues. Now, just very quickly, almost on the wrapping up of my 5 minutes, I would say that the provision has a number of, let's call it, risk mitigation measures, including recognizing some mandatory exceptions that some people, including myself, consider user rights. I've organized with 60 academics endorsed academic recommendations on how to interpret this provision in order to safeguard user rights, but the fact remains that the incentive within the legal regime is to have preventive measures, and those probably look like the type of filtering I'm mentioning. Now, at the final point, in a recognition of the complex nature of these measures, the law itself, the last paragraph of this very complicated article says, well, let's try to define some guidelines to implement this at national level through commission stakeholder dialogues. We're right now with 5 commission stakeholder dialogues, and the best that can be said about them is that it's a sort of epic fail. You have put 90 people in a room trying to get an agreement with different agendas. Some of them want to keep the status quo. We can talk more about it, but the outcome of this is that we'll probably have, if any, useful guidelines, very few of them. So the problem remains for national implementations. So I think I would leave it at that for now.
Thank you very much, Joe. Comforting to know that the first steps in the implementation procedures are an epic fail. We move to Rosanna.
Yeah, so I'll try to start with a bright side from the data protection perspective, in the sense that there are two good news in the copyright in the Digital Single Market Directive. Essentially, Article 17, but point 8, establishes that there is any kind of general monitoring obligation that Article 17 is going to trigger. That's the first statement, the first article. And then the following, point 9 of Article 17, again, provides that the directive, the copyright directive, shall not lead to any identification of individual users, nor to the processing of personal data, except in accordance with the data protection framework. Okay, this is already a little bit complex to, it's just an example of how this Article 17 is not very, is not written in a very plain language. But anyway, what's the main issue? That the processing of personal data is not excluded a priori by the copyright directive. And when it occurs, it has to be done according to the data protection framework. Now, why it's going to occur this data processing in the context of upload filters in this case? Well, essentially, if we have to ensure, if it's necessary to ensure the unavailability of copyright infringing materials, plus if we have to ensure the compliant redress mechanism, we have to process personal data. Furthermore, as Joao was mentioning before, if we are taking seriously the copyright exception as users' rights, the Article 17 is pretty clear in saying that users' rights must be respected. So certain kind of exception cannot be limited by the measure that are going to be implemented according to Article 17. So the disagreement between the right holders and the online copyright service provider cannot prevent to make available this kind of content. But if we have to understand whether there is a satire, a parody... Excuse me?
Closer to the mic.
Sorry. Okay. So essentially, if we are going to understand whether these users' rights are there, we have to process the content.
Harder, louder.
Louder. So, essentially, we have to analyze the context to understand whether the user's rights has been respected. So again, a processing of personal data. And the fact that the data protection system, the data protection framework has to be respected is also confirmed in Article 28 of the copyright in the Digital Single Market Directive for the whole processing that are going to take place within this directive. So essentially, it's possible that it's going to be this kind of process is going to entail not only the processing of the content itself, but also of the metadata, if we have to understand the context where the content has been uploaded. So anyway, apparently there is this hierarchy between the GDPR and the copyright in the Digital Single Market Directive, but in practice there is a lively interplay between the two of them. And that's why it's going to be very important to look to follow with a certain scrutiny how Article 17 is going to be implemented into national legislation in practice. So in light of this kind of dialogue between the GDPR and the copyright in the Digital Single Market Directive, in particular Article 17, as you probably know already, several concerns has been raised. First of all, is Article 17 going to imply a sort of generalized surveillance? And then, if there is a processing of personal data for this kind of purpose, what are the legal bases that can legitimize the processing of personal data in this case? And if the content is actually about political opinion, for example, because in the video I'm saying something expressing my political opinion, it's going to be sensitive data. So what's the legal basis in this case? Plus, as Joao was already mentioning, this kind of the filtering system, as at least we are studying them right now, seems to be pretty automated. So if the concrete functioning of this measure is going to result in a solely automated decision-making processing, so maybe we should also consider Article 22, and so also what are the possibility and the exception to that. And I'll leave now the floor to the next speaker.
Thank you very much also for perfect timekeeping. Yeah, lots of complicated questions of the interplay between the Copyright Directive and the GDPR. Then we move to Anna.
Thank you. I want to briefly talk about, first of all, the practical and immediate kind of maybe not yet consequences, but steps that come out from actually adopting this directive. And I would like to talk about the three aspects of it: the oversight, the risk or the risk management, and the spillover that is happening in terms of content filtering as a remedy to the perceived problems. So, as João mentioned, we do have this stakeholder dialogue now that is not really a dialogue. It's more like, people used to go to King and petition him, and the King was completely silent, and then, whispered into somebody's ear, and then maybe there was a verdict coming out, and it really resembles that more than a dialogue. So part of that is the fact that it's kind of this whole liability question is difficult and nobody has a good answer, and it's this hot potato that the legislator actually pushed then on the Commission to figure out. And what we also see there is that there are three kind of parts of the society, so to speak, roughly present there. And I, on purpose, kind of avoid the word represented, so the rights holders. And it's important also to say that, of course, they represent certain parts of industry, but there is also a conversation to be had whether that's, industry and whether they are creators and artists, and what is the difference between the two. Because not every rights holder is an artist or a creator, and then we have the obviously the Commission and the public sphere, but also we have the civil society, and it's important to underline that as civil society we don't, and I say we because Wikimedia is also a part of that group. We don't really represent the citizens or the users in a way that the industry represents their interest or their members. So there is a question about how we can actually, what is the takeaway about the oversight that is being now run over the whole process of deciding what this provision should actually look like in practice. So there is a petition or a letter to the Commission to actually run a consultation on the draft guidelines, and we'll see, what the King will whisper to the ear of the person, sending a response if there will be any, but that wasn't an original plan. So it is, I must say, to me, really worrying to see that we actually have something so important, and there is little reflection put into, how this sort of precedent in the law will be framed, and also what sort of knowledge we bring into that process, because knowledge also can come through that consultation. Then, of course, there is another way of dealing with the hot potato, which is basically just, eating it quick, and this is where France and the Netherlands come in. They don't wait for their guidelines. They just proposed the versions of Article 17, and it's important to notice that in the conversation they would always be on really opposite sides of the filter conversation spectrum, so to speak. So France would always push for filtering and for strong protection of copyright, whatever is the way they understand it, and the Netherlands, they were skeptical, to say the least, and also opposing a lot of the filter conversation. But now, actually, when you read the ideas that they put out in the form of those draft implementation legislation, you see that this is not very different. And this is the paradox. They basically, there's a very good comparison done by Comunia Association. If you go to Comunia Association .org website, you can see in details what is the provisions, but the bottom line is that, they just basically, they don't sort of elaborate more on what is being said in Article 17, which still, appears that this hot potato is going down the line, and who will be the people that will have to handle it, or the groups that will handle it. The legislator does not want to do it. So there will be obviously the platforms, and I don't, feel very sorry for Google or Facebook because they can handle that, right? And I would argue that for those companies, it's very important to have legal certainty over legal uncertainty, and this is what they have right now, even if it's difficult. But the small ones will handle it, right? And then, and of course, then the users, right? So the risk management is basically no management at all, is just pushing it down the line. One last remark, and please stop me because I can rant about this forever, is the spillover, which is basically the fact that we also see it in the terrorist content regulation proposal. The Commission did their homework, so they do not use any words that could actually resemble, content filtering. They say talk a lot about proactive measures, but of course we know it boils down to the filters. And I want to say that if in copyright it would have been so easy to establish who is the rights holder, where is the breach, where is the legitimate use, we would not need courts to do it. And yet, still people go to courts over that. And somehow magically, the Commission and the people who supported this proposal in that particular line believe that terrorist content, again, whatever that is, I still don't know, will actually be even easier to do when we know it's context dependent and it really is about how people express their political views. So these are my first points. Sorry to go over them.
No problem. Thank you very much. Then we move to Asta.
Well, thank you so much. And I'm supposed to give my deepest, warmest regards from Karen Melchior. She was unfortunately had to go to a group meeting because Brexit is happening in 9 days and nobody knows what's going to happen, and they're trying to figure that out. So I'm very sorry, but I'm here and I know a few things about this topic, so I should be able to at least spread some light on it. To actually take it forward, because what the Copyright Directive essentially did was they backdoored into the liability regime. They backdoored into the current e-commerce directive in order to actually try to, in a way, cherry pick liability based on what kind of content we are talking about. So the type of content here in the copyright directive is, of course, copyrighted content, which, ironically, is basically almost everything. There's not very much that is not copyrighted, except for maybe shopping lists and things that are in public domain or something like that. This is something that actually has been the dream of various regulators for many, many years, that they can somehow control how content control on platform actually is. And in many ways, that is understandable. We actually do have platforms that actually are quite big. They have quite much influence on political and societal debates. They are influencing how we actually, live and do and whatever. And the current, and because, the e-commerce directive basically existed before we had social media. It existed before we had YouTube. And in many ways, it actually is outdated, but at the same time, there are many good principles in there that I believe that we should actually continue. And that is like the intermediate liability and the ban of general monitoring. And one of the things that is basically the result of the Copyright Directive is the review of the e-commerce directive, which is the Digital Services Act. And there are certain things there that we actually have to consider, especially when it comes to like data protection. And that is the importance of actually continuing the ban of general monitoring. Because the ban of general monitoring is a precondition in order to actually be able to have a secondary liability. Because if you're doing general monitoring, that basically means that you are looking for illegal things that are not supposed to actually be there. And you're doing that either because you're doing it voluntary, which many platforms are already doing. eBay is voluntarily looking through almost every single post, I think every single post that is actually posting there, in order to actually check whether or not this is something legal, whether or not somebody is actually trying to sell some cocaine or crocodile or whatever that is. Same with Facebook, it's more or less actually doing general monitoring already. YouTube with Content ID, but this is voluntary. By actually making them do it, that basically means that they actually have active knowledge of something that is illegal, according to the law, and then they don't really have secondary liability. And this general monitoring provision is there to actually protect human rights and the freedom to conduct business. Because if you actually have to go through everything, and if your algorithms are actively seeking some information, what can you actually do with that in terms of profiling? What can you actually say about the person that's actually there, that is trying to actually upload something? One issue that I've actually been noticing lately is that there seems to be a division between what we would actually consider as general monitoring versus what the courts or even the commission sometimes actually seems to be general monitoring. And that is that when you actually do have some kind of algorithmic filtering, when you are looking for just matches, whether or not this is Mickey Mouse or not, whether or not this is some kind of illegal hate speech or not, whether or not this is, whatever or not, when you're basically using algorithmic matching technologies, that is somehow algorithmic monitoring. And general monitoring is only there when there is like a human involved somewhere in the system. And I think that is a very dangerous distinction to make. And this is something that was actually the European Court of Justice maybe said in a recent judgment against Facebook. But there is like much uncertainty about what and how general monitoring basically should look like and what general monitoring is within the current status quo. I don't really have that many minutes, and I'm just going to say thank you and wrap it up here. I could talk about this forever as well.
Thank you very much. You have, as you have noticed, not too much enthusiasm here in the panel over the filtering, not quite obligation, but in practice obligation in the copyright directive. But I suspect that some copyright holders organizations might think roughly as follows. There's platforms such as YouTube. They don't publish their own music videos generally. They don't publish their own movies generally. Lots of the platform is filled with our content. YouTube is basically a money printing machine for Google, Alphabet. We should get a cut, and therefore this safe harbor from the e-commerce directive is old-fashioned and should go. Because for the non-specialists here in the room, and the panel members can improve me if I summarize it too bluntly, but the e-commerce directive was written basically in the late 90s, and the idea was the World Wide Web will not grow enough if hosting companies are responsible and liable for everything they host, because then there's no companies that want to host websites. That would be a problem. Therefore, the e-commerce directive says if you host stuff, content for other people, you're not responsible for it, unless you are warned this website, for instance, has a guideline to build a bomb, or this website has an illegal copy of a movie. If you take it down quickly, you're again free from responsibility and liability. That seemed back then a good idea. Little did policymakers realize that the YouTubes in this world and the Facebooks in this world would also say, we're just hosting other people's content and we're not responsible for anything. And those companies became the most powerful companies in the world. So that makes some policymakers and many copyright lobbyists say, no, we should make platforms responsible for everything that happens there, because it costs us money, and they have enough money anyways. Panel members, we do one more round, and you can react to my hypothetical remarks of a copyright lobbyist, or you can react to each other, or you can just randomly add new points. And then let's try to keep it a bit short, because then we can move to the audience. Meanwhile, you, audience, can think of remarks and questions, and you can also think of how to formulate them very briefly and concisely.
Maybe if I could just quickly, because I mean, this is this question about what we're supposed to actually do with social media platforms is actually huge, because it's a question about like to what extent is a social media platform actually to what extent do they actually have to or are obliged to respect fundamental rights, such as the right to privacy, freedom of expression. At the same time, they are curating content. They are prioritizing certain type of content. And that is, you know, and we don't know exactly how that functions or how that is affecting society. You know, that is, I think, like what is really difficult about this, you know, is that this distinction between responsibility and liability of social media platform, because the responsibility is not necessarily clear, because there are actually simply not so many things that we simply don't know how, you know, how the algorithms actually work. Is it true that they are basically, you know, if you go to a YouTube loop, that you will end up with like more extreme content because they're trying to actually gain your attention? And then it's a question: what is, you know, what is the social responsibility of YouTube to actually stop at some point? And the same is like, what is the social responsibility of YouTube to actually give artists a platform to actually potentially make, you know, their own music available, and how does that actually feel, you know, come into the ranking system? And so that is, I think, like this curation of content and content control actually is very interlinked, and something that is a way bigger discussion than just about privacy.
Thank you very much.
Maybe. Yeah. I don't know. Can I add it?
No, just because it's related to this. No, it's true that there is this huge debate, but you know, of course, about how to regulate online platforms. Should be they regulated? We should search for co-regulation, self-regulation, and so on. And precisely about ranking, there has been a recent consumer protection, the so-called Omnibus Directive, that has introduced some specific transparency obligation on online marketplaces. So essentially, they are going to give some specific transparency information about how, for example, the ranking is created. So in a way, this is related to what Asta was saying, that probably there is a silver lining in the regulation, in the sense that at least this kind of acting are becoming transparent, object to some form of control. But of course, this can be a really slippery slope argument. So where do we fix the line?
Well,
Thank you.
Well, the only thing I would like to add is that the problem with this whole situation for me is that copyright acts a little bit like a Trojan horse, right? If you look at the first communication on tackling illegal content online, you have copyright bundled with terrorist content, hate speech, child pornography, and other things, which let's admit that there are severe differences in harm. And what we've done with this directive, through force of lobby, is not only create a backstop, but actually impose on a huge number of a subtype of hosting platforms obligations that were discussed and continue to be discussed mostly vis-a-vis two major platforms, especially YouTube, which as the added element of there's currently a preliminary reference in the Court of Justice precisely on the question whether YouTube, by curating content and doing certain of these activities, is actually communicating works to the public. So the court is going through this problem already on a case-by-case approach, and what we've done here is the legislator basically has stepped over and given a very broad sword to rights holders and then a total new qualification for a problem that was mostly sold as a YouTube problem if you read the documents and follow the debate. So this is part of the issue is there.
Thank you very much.
Yeah, I think we could make another panel titled Weird Things Lobbyists Say. I can say that, I'm a lobbyist. But I will just talk about one thing that I think is very important and kind of obvious, and we all know this, but I feel it doesn't get enough attention, is that true that the internet changed and the technology is changing and the way people interact with content and produce it changes, and we all know that. But if we look at the e-commerce liability protection or liability exemption, it is not only about companies being protected, it is the users that are being protected by it just as well, or even more. And while the technology has changed and our reality changed, we actually did not have a societal discussion whether we want to change those privileges or those rights, which is a much better word, that the users have. The right to privacy, the right to freedom of expression, and so on and so on. So I feel like we're trying to fix something, forgetting that there is a lot behind that protection that is not a negotiable thing. Also, I think it was kind of mentioned. I think that copyright becomes like to the legislators what Bitcoin is to Silicon Valley. Everything can be, or blockchain maybe more, everything can be solved with this all of a sudden, right? So if we talk about wealth of the platforms, let's look at the ecosystem they operate in, and let's look at who is their real client. And I would argue that this is not the users that interact with content, but other companies that either want to advertise or benefit from advertising their products, right? Or offer those services. And if we look at this from this point, we can have a very different regulatory angle that is much more comprehensive and better in solving responsibility issues and does not backfire into a very, or doesn't morph into this very successful and popular strategy that is basically privatizing the profits and socializing the losses.
Thank you very much. Then you, the audience, have a chance to react. Is there a working microphone?
There is one in the
room. Perfect. Oh, there's a microphone there. We're going to take 3 questions and then we go back to the audience. Please be brief and also say briefly who you are and if you want. You're not obliged.
Thank you very much. My name is Andrei Sherbush, National Research University Higher School of Economics of Moscow, Russia. I'd like to tell you about my concern about that people in the social networks, for example, while using platforms, they are realizing their constitutional rights. For example, for communication, for their privacy, it's also their public rights that guaranteed by the Constitution. Yeah. But according to the terms of service, they are limited to the contractual obligation of the company, which is also limited by the zero protection of the zero prices service. Yeah. For example, according to Russian legislation, which is free of charge, for example, email services which are completely free of charge, they are not even under the consumer protection. So because of the producer, so to be a consumer, you need to buy for something for money. So because this is a big problem. This is a big problem. How to solve it? And we need to reconsider terms of service as something like public law agreement, which makes platforms more responsible. And they should be also universal to be accessible for users all around the world. Thank you very much.
Thank you very much. Good points. Is there any other questions for the moment? There, yeah. Free services and consumer protection.
Hi, my name is Divij Joshi. I'm a Mozilla Tech Policy Fellow from India, where in fact a lot of these debates are currently happening. In fact, at the end of the month, there's a proposed
Sorry, are the same debates happening or not yet?
Very similar debates.
Yeah, okay, thank you. Yeah.
They're proposing guidelines which would require automated filtering of certain forms of content. So I think at least the panel seems to be in agreement that automated filtering does not currently work in terms of considering the context or the socio-political implications of filtering. But has there been consideration of alternatives to technological fixes to these problems, right? Because we have systems which kind of try to strike a balance between access to content or access to knowledge or cultural goods, while keeping rights holders in mind, such as extended collective licensing in Nordic countries. So has that kind of figured in the debate at all around Article 17 and the EUCD? And has there been any push to kind of implement those structural changes in the laws which attempt to strike this balance instead of purely looking at technical fixes?
Thank you very much for your questions. Are there alternatives? We noted them all down. More questions for the moment? There's nobody. Yeah, please.
Hi, my name is Hamni Vivina. I'm a French lawyer and also a security and privacy manager for an ad blocker. So I'm blocking ads.
Thank you.
I have a question. Isn't it disturbing for you to have private companies becoming sort of the judges of intellectual property? Because as lawyers, we are always like having argument of is a new creation original or not? Are we under an exception? Is it in the public domain? And so on. And the other quick question is, do you, in my opinion, something that is really bad is that with this article we are putting the intellectual property above freedom of expression and also public domain. Because public domain is now it's public interest. That's why we put an end to the intellectual property right. Is at the end, everyone can profit the benefit of new creation.
Thank you very much for your questions, and thank you everybody in the audience for being brief. Anybody who wants to react first?
I can go.
Joe?
Yeah, I can start. So very quickly, from the gentleman from Moscow, I think it is a really good point. I would just note that actually Article 17, if in my view correctly interpreted, already provides that terms of service from platforms should not override the exceptions and limitations that are defined either as mandatory exceptions or user rights in the provision. So in theory, a platform, those provisions in my view would be invalid. So there's already something embedded in the law to that effect. Although I echo your larger point about qualification, setting aside consumer law provisions on the basis of the free of charge nature of services provided for platforms is problematic. From the gentleman from India, indeed, this has been discussed, collective management in particular. If you're really interested on the topic, I have a whole paper with Martin Usuvek on that. But the point is, so self-promotion, but the point is that even the rights holders disagree on this. So the music industry, what they actually wanted is to negotiate in the shade, not of the intermediary, the safe harbor, but of primary liability. So they're pushing for that. Whereas the audiovisual industry...
Wait. The music industry is pushing for
collective licensing. So in the stakeholder dialogues, they're very favorable to this idea, whatever model you choose. And usually the two models on the table are voluntary or extended collective licensing. I think there's space for mandatory, but that's a more controversial opinion. On the other hand, the audiovisual industry is not. So their whole business model is based on windowing and restrictive exclusive distribution. So they're more pushing towards the filtering aspect of the provision. So that's where we are. As regards the last comments on privatized enforcement, unfortunately, we've been going there on platforms since the decision in UPC Telecable. I think there's a problem in the article. You can read it one of two ways. I read it as actually there's a hierarchy of exceptions over the filtering or preventive measures, but not everyone reads it like that, and it's very difficult to implement it in that way. So that would be my short comments.
Brief remark, we have all these copyright specialists here, and I know that you are a privacy specialist. Is everybody, raise your hands and don't feel ashamed if collective licensing or any other phrases are unclear that are used. More?
Copyright is traditionally defined as an exclusive right, and that means that there's a possibility of individual licensing. So I own a right, I license it to Frederik, but there's also a possibility, due to the difficulty in transaction costs for certain uses, think broadcasting, or even certain online uses where you say, well, you know what, let's pool all our rights in one organization that represents us, and let's let, for example, the broadcasters or the online service providers go to that entity and they get a blanket license from them. So the question here would be, for these types of platforms, could we devise such a system within the law and the letter of Article 17 that would allow us, instead of having to do negotiation with each rights holder, to actually go to a collecting society that exists in every country to obtain such a license in very simple terms. Sometimes these things are voluntary, meaning that rights holders pool and decide whether they put their rights in this organization. Other times the law actually imposes that on rights holders. The law says something like, you know, it's very tricky and muddy for a TV station to get rights from everyone. The liability risk is enormous. So for that type of use, broadcasting companies can go to that organization, they pay a fee, that organization then distributes that fee according to some metric to their members, or whoever goes there and proves it's a right. So is an author.
Thank you. And again, if we by accident use too difficult phrases, please wave, and we amend our ways.
Shall I?
Yeah.
I'd love to. Okay. Go ahead. Okay. To the lady over there that said that we are putting IP above freedom of expression, intellectual property rights and copyright is de facto monopoly of information and is limiting freedom of expression. And that is because it was, created in a time and a place where actually creating and especially manifestation of expression, like how you say something is copyrighted. It does not mean that all words are copyrighted if they're just a jargon. And this is because, back in the time, information was scarce. And access to information was scarce, and reproducing information was difficult. But now we are in the exact opposite, where actually information control and filtering of information is actually more valuable. Making sense of information is valuable. And that is why intellectual property rights and the internet do not necessarily always agree. And that's why especially more conservative, copyright conservative countries such as France or Portugal want to actually have more direct liability to platforms when their users are infringing on something. But that in return creates liability regime on platform, which means that they essentially will have to spy on their users in order to actually figure out whether or not they're doing something that is criminal. To the Russian gentleman, the question about platforms is also what role do platforms actually have in society? Are there public spaces or are there private spaces? And if there are public spaces, what kind of space is it? If it's a private space, can we put on some obligations on them to actually respect some fundamental rights? Or is it just that it's a business, and since it's a business, we can't really do anything? And as a Northern European, I think that businesses should also actually have social responsibility. But that is, also a philosophical market economic decision to actually make, and that is much broader than necessarily just privacy. It's also about and maybe we can actually control that as Anja actually was mentioning about, we have to look at the ecosystem around it in order to actually regulate it rather than actually regulating the content. And then, of course, we are referring to the ads. Lastly, about the Indian guidelines. Automated filtering is basically content recognition technologies. And we can, of course, use content recognition technologies for different reasons. We can use it to actually flag potentially illegal content. We can use it to flag definitely illegal content, and we can use it to flag possibly illegal content. And then what happens after the flagging, that is, that can actually be, several different things. Much of automatic filtering were basically first developed in order to actually prevent the spread of child sexual abuse material. Child sexual abuse material is almost universally illegal. We always know that it's illegal. We actually have, as a society, as a continent, even as a world, mostly decided that child sexual abuse material is absolutely, you should not do it. It's disgusting. You go to jail. We cannot really say the same necessarily always about, for example, hate speech, or always the same about defamation, or always the same about copyright. So we can use things to actually flag, but what actually happens after the flagging? Will we actually have human reviewers to actually say, no, this is copyright, this is a satire, therefore you actually do that? Or do we actually automate it somehow. And then there's a question to what extent and how and why, and who is actually calling the shots, who is actually creating the yes or no, the binary filter to actually say whether or not this is okay or not.
Thank you very much. Anna?
Well, there's obviously a lot to elaborate on all of those questions. So let me just pull a few threads there. I want to follow up on what Asta said. I think it's super important. I think although maybe not very complicated in seeing this, that private actors, so companies that run platforms, perform the role of public spaces right now. And I think this is a very important distinction. They are not public spaces, but they start performing this role to the point where it could be argued that if you don't have an access to them, or if this access is required for many other services that we have, we basically lose access to those services, right? If we don't want to use Facebook or other platforms. So this is something that, again, is completely separate from the copyright discussion. It's separate from the freedom of speech discussion in the particular context of what is legal or what is not legal, right? So and this is the conversation that Europe is successfully not having. And I think this is a big problem. And I hope that we can have it somehow before we actually start discussing the Digital Services Act and other legislation that touches upon that. About the terms of service, because again, private actors, therefore they have those. I am actually in favor of having some sort of a regulator that would, and this is again, it is not a panacea to all the problems that we have with the current online ecosystem, but to some of it, it could be a successful remedy. And I think there are at least two things that regulator can do. One is to use an analogy from different sectors in some European countries. I know in my country, in Poland, basically when you want to take a mortgage or you have any other contract, you basically also have like a list of clauses that cannot go into that contract because they were proven in practice to be misleading or unclear, or actually putting people into a situation where there are some hidden fees that they agreed to because they couldn't understand the consequences of it, right? And I think if we read terms of service, there's a lot of that sort of talk in there, speech in there, right? It's not only because people cannot understand the technical implications, right? But for example, what platforms do, separating the privacy conversation from advertising conversation. If you go on Facebook, these are two different sections in the settings, right? So and Facebook pretends they have nothing to do with one another, and that's not true. The second thing, it could be that it could actually audit the terms of service that are already there, and also look, first of all, it's, I don't know, long, it's incomprehensible, it should be changed, and so on and so on. And so I think this could be one of the things. And this is not, I guess, really a panel on copyright, but just to share with you that if I want to raise the blood pressure of industry lobbyists, I kind of say two things. One is that basically everything is public domain, and copyright is just an exception to it, because basically it's time limited. In Europe, in most cases, 70 years after the death of the creator, it expires. So we just need to, wait or live long enough to experience that. And the other is that the exceptions from copyright are not a favor; they are a right. And I think it's very important to see how that thinking is, again, there's no uptake of that thinking, because obviously the algorithms and the filtering does not understand context, and context is where the exception actually takes place.
Thank you very much. If filters don't work, should these big platforms just hire thousands of people to do it manually, perhaps? You can react to that or to the audience.
Yeah, no, I was thinking, just to play the advocate's devil.
I like that expression.
Is it actually an idiot or maybe it's two different things? Regarding the trying to defend the copyright a little bit, I mean, there is also an economic rationale behind that, and in Europe we have the tradition of droit d'auteur that also protect the author, pay more attention to the author. We need to, I mean, there is also the economical incentive of copyright is that without copyright then there is no incentive to create. So we must in a way protect the authors, foster creativity, and so on. So these are the classical justification to intellectual property in general. And then there are some clear limitations, like the temporal limitation that you have already mentioned, the exceptions, and so on. Then, of course, we must debate whether we are witnessing to a commodification of information that is going beyond what was copyright at the beginning. But at least it is recognized as a fundamental right in the European Charter. So these are also some elements that we might take into account in the debate. And then you have touched also another topic that is I'm particularly fond of, about the role of terms and condition and privacy policy that are actually implementing a sort of private ordering mechanism. Well, we should make some distinction in the sense that the private autonomy contract is not a freedom without any limit. I mean, there is the Constitution, there are some mandatory provisions, the contract cannot go against the law. So what actually the private ordering through terms of services and privacy policy are doing is that exploiting some gray areas, they are imposing de facto some terms that should be considered illegal. So the problem is that we don't have the time, the effort to challenge the unlawfulness of the terms. And Dana was rightly mentioned some alternatives to try to solve the problem in practice. And artificial intelligence can actually help for once, because there are now some tools that help consumers or consumer association to automatically scan terms of services and privacy policy to find whether there is a potential violation of a legal provision.
Thank you very much. Anybody in the audience? Yes, please.
I had a question for João Pedro Quintes, because at the beginning you mentioned something about contextual filtering. From what you were saying, I gather that it's your view that a third party content provider is also covered by the same exceptions as the users. Is that your view?
So no, what I mentioned was there's two markets out there, or these tools exist in two realities. One reality is in-house, and the examples I gave. So I'm using the examples that are public and were discussed in the stakeholder dialogue. Facebook Rights Manager and YouTube Content ID. There's a lot of information on those. Also, there's a lot of opacity. And then there's a number of other companies that made presentations there. And this was Audible Magic, PEX, Vid Identifier, and Smart Protection. What I was saying is that these, obviously, it's an off-the-shelf, a small platform that's not Google or Facebook will have to hire. If it wants to comply with these measures, we'll have to basically obtain a license to use this type of software. And of course, the platform itself would be the liable party if there's problems with the software. Now, an interesting question is what obligations are on the producer of such a platform, but I haven't touched upon that. That would be more complicated.
That's what I thought, because clearly, for example, from my point of view, YouTube would not be able to invoke the exception that I may invoke or not. For example, private use or parody or whatever.
No, sorry, maybe I wasn't clear. Like, who invokes these exceptions are the uploading users, right?
Yeah.
And the question is, who do they have redress against? They usually have redress against the platform where they have uploaded. Now, the platform can use software that's its own or software that contracts out, but I guess this would follow a traditional civil liability tort where they would ask for their software provider in case there's defective software, something like that. But what I was talking about is the user redress vis-a-vis the platform and the software it uses.
Thanks.
Thank you. Other questions? Yeah.
Okay. Hi. Oh, that's really loud. So I from more of a technical background. I study at Eindhoven University of Technology, and like you said, the algorithmic filtering is really hard, will probably never be possible, and I don't think Google can hire enough people to like filter everything on YouTube. So is it then maybe time to give up the fight to filter if it's not algorithmically possible nor human possible? What else are you supposed to do? What else are they supposed to do?
Good.
Maybe part of what Asta mentioned is what is the consequence of the match, right? If the filter allows you to match, what do you do with that information? Right now, the system is designed with some options, but there are two basic options in the systems that I've seen. You monetize or you block. By default, it is blocked. And then the user, the rights holder has a period of time where it decides, do I monetize this or not? I think one of the options you mentioned, maybe you can talk about, is you can do other things than block.
You can monetize first and then block, or you can even flag and then do something, notice and takedown or something. But there's also like one thing that is also important to actually mention in the context of filters, and that is that the internet as an information channel is extremely overloaded with information. We do filter a lot of things on the internet already. Spam filters are examples of filters that are actively filtering the information that you also get in your email. And we think, okay, sometimes your email actually lands in the spam folder. And we think that is an acceptable collateral damage in a way towards sending and receiving email, because otherwise we would be flooded by, people that were asking us on a date because they actually wanted to give us $1 million, Nigerian princes and I don't know what. And this is like, we accept this as a collateral damage, so sometimes you actually need to look in your spam folder in order to actually, get to know whether or not, your subscription was actually notified and things like that. The question is that, when we are actually doing filtering, for example, of copyright, or even when we're actually doing filtering of one specific case, such as defamation, whether or not the collateral damage of everything that actually might be falsely considered positive match, a false positive, if that one basically is higher than the true positives. So that is the ratio that we actually need to look at when we're actually looking at filtering, and that really depends on the population of content that we're actually looking at and how rare that content or that type of content is in the total population of content. And then, of course, we need to actually decide, is it child sexual abuse material or is it copyright infringement? Because it's like copyright is everywhere. Everything is more or less copyrighted. Not everything is like defamation. Defamation that has been actually defined as defamation according to the courts is relatively rare. And different courts in the European Union actually have different standards about when defamation actually happens. So is it fair and proportionate to actually use filters in the case of defamation, for example? Or will that actually cause damage toward freedom of expression and privacy? So that is like this is like the base rate fallacy. You can look it up on Wikipedia. They actually do have a good explanation of that. But that is the base rate fallacy of filtering is actually, what we actually need to look at when we're actually doing algorithmic filtering for content control.
Thank you very much. Any reactions of you? And perhaps you could also, if you want, speculate on if you would be a policymaker, what would we have in 5 or 10 years from now? Does it perhaps make sense to have, for different types of content, different requirements for platforms? I could, for instance, imagine that you say, after flagging revenge porn, that should be taken down like super quick, to 15 minutes. Copyright, you can take it a bit easier. Perhaps different regimes for different type of content, and then for some types of content filtering, and for other, or react to each other.
Yeah, no. It's a super interesting question. If I have the powers to realize everything, yeah, it should be great to have a system so perfect that I can exactly tailor my algorithm and perfectly detect, depending on the type of interest that at stake or the kind of harm that can be produced. I don't know whether it's going to be possible in the near future, the principle, I must say, I'm not totally against it, actually. And we are also moving toward this kind of granular law and personalization of law. So, again, speaking a little bit abstractly, if there is the possibility to profiling for bad things, why platforms that have all this data cannot actually profile for good and use all this kind of information that we have available to create something that can serve a public purpose? So, yeah, we'll see.
Thank you. You?
Yeah, I think it's important. The technical perspective that you bring is important, and in a way, I feel like we keep having this discussion and keep bringing those arguments, and again, somehow they don't get the good uptake with the legislators. Namely, that it seems that a lot of legislators, and I think. I don't know this, but I think it's because companies just talk to them and give them that sort of assurance. First of all, they believe that the technology is there to do it properly. Second of all, they believe that when you create market demand, that technology will appear, even if it's not there. And of course, then we have the magic spell of AI that will solve all our problems. I think I say maybe somewhat provocatively that we should be so lucky to end up with a really good AI. But my concern is that we end up with a crappy one, and then it will not be anything that will solve. In short, technology is the answer. What was the question, right? This is what we keep missing, and the filters that we can see a little bit of. Because there, like for this stakeholder dialogue, there was a presentation by, I think, Google for sure, YouTube showed something, that we see that basically this is this more like big data matching operation than anything else, right? And the problem is that with copyright exceptions, there is no debate that the content that I publish under an exception belongs to somebody else. Of course it does. That's why there's an exception. Like that's the whole point. So, so this is not solving again any of the problems there. I think for regulatory ideas, I cannot say this enough. We should be bold in looking at the whole sort of layer cake of what it is. I also sometimes think on a bad day, and we just had the Blue Monday, so that was quite recently, that maybe internet is just broken, and the way it functions now is actually not sustainable. And that comes with both with data protection, with behavioral profiling, with when you say, Rosanna, let's use this data for good, I kind of start to tremble, because I'm thinking about all those sort of like public policies that based on the knowledge about the people are nudging us into doing the good things, And also one of the nudges that we are now experiencing is the conversation that is framed as the disinformation issue or fake news issue. To me, it's also a conversation about the real conversation behind it is whether I have the right to read lies on internet. I think I do, if I want to, right? So this is also a part of that. Nevertheless, being more practical and less, party pooper here, I think that there are some things that we should consider. You mentioned the responsibility framed as the responsibility for actually moderating the content in a way that is being done now, so that there are actual humans that go through sometimes horrible images. I'm sure you've all seen the documentary The Cleaners or any other material on it. This is not being treated seriously enough. People from same cultural circles sometimes do not get sarcasm or do not get the joke, and now somebody said somewhere else, not speaking the language, not really being in a culture that he or she is supposed to evaluate, is now going to take those decisions. So what is one idea to deal with that? I would argue that the platform that wants to offer services in a member state of the union should actually make a case for itself, presenting that they have the capacity and the potential to service that culture and that language. Because this is not happening right now, and we get all sorts of mistakes.
Thank you very much.
Okay.
We have
So very-
6 minutes left.
Yeah, so very briefly, if I had a magic wand, right, and could not use blockchain to solve all the problems, well, I would say from my perspective, I think we have to take a step back and actually try not to use copyright to solve a lot of the problems we're trying to solve. I think this is a broader issue about whether we want to call it intermediary liability or responsibility, and not an issue about verticals here. So first we have to decide what are the general principles we want to apply. And so I would like to see in the DSA that approach. Because
DSA?
The Digital Services Act, that's going to review the e-commerce directive, sorry. I would like to see that approach. I think some of the principles that are healthy, and we've had like a ban on general monitoring and an actual horizontal agreement while general monitoring is also for data protection purposes is extremely important. And one thing I would like to see...
4 minutes remaining. 4 minutes.
Thank you.
Wow, awesome. One thing I would actually like to see is paying closer attention to regulatory regimes that deal with platforms at scale. This is a content moderation issue at heart, if you define moderation broadly. And we have competition law that deals with some of these issues, but I think in intermediary liability we should start thinking about this problem. And yeah, the elephant in the room also with privacy, which is the advertisement model. Right? We really need to tackle that problem before we try to, for example, using the backdoor of copyright, try to remunerate artists out of a piece of an advertising revenue. So I would keep it at that. Move it over.
Yes. This is a big question. This is also like what we are trying to actually find the answer for. But what, currently, because those kind of questions are actually quite recent in the political debate, I seriously encourage people here, both of academic backgrounds and, if you're working with privacy more professionally or technically, to actually engage with the policymakers. Because much of the issues that we are having is simply that we don't have enough information. Privacy is going to, of course, be part of the Digital Services Act, and how we actually frame, if there's going to be a second generation of intermediate liability or secondary liability or whatever, or that we are going to say, okay, for algorithmic monitoring, we actually need, not only lobbyists that actually come from like Google or Facebook to actually come and knock on our doors, but also just, interested people, because, you are, mostly like the European citizens that the European Parliament is supposed to be, regulating for. And that is something that many regulators actually do not necessarily, or like legislators actually don't necessarily get, is that they are not there to actually regulate for the companies, but actually there to actually regulate for the people. And it's not the companies that actually elect them in democratic elections, but you guys. So, I encourage you to just actually follow the debate of the Digital Services Act. It's going to be quite broad, but actually getting some expert knowledge, whether it is about privacy, copyright or intermediate liability, or even technical, that is very valuable. So I just welcome that and hope that, we're going to have 5 years of fun. Copyright times 2.
Thank you, audience. And thank you, João, Rosanna, Anna, and Asta. I hope you're not disappointed that we didn't solve everything yet, but we'll do that next year in the panel, I guess. Thank you, and enjoy the rest of the conference.